First of all, my name is Shawn. I'm the Associate Dean for Centers and External Programs here at Washburn University School of Law. I'm stepping in for Dean Pratt, who would have loved to have been here, but had a family matter she had to attend to today. So you get me, you get one of the Associate Deans rather than the Dean. So we'll just have to deal with that, I guess. First, I want to say Washburn School of Law has always been very proud of the role we provide in serving as a resource on current topical legal issues for our students, the practicing bar, our legislative representatives, and our communities in general. To that end, we're very pleased to bring together today a broad variety of scholars and experts to speak on artificial rights. This deeper look into a facet of intellectual property law as it intersects with other areas of law is especially timely, as our faculty recently approved a certificate program in intellectual property law to be executed and led by our own Professor Patricia Judd, who's going to be moderating one of our panels today, the first panel actually. She's out in that green breakout room as we speak. For our students, this is an opportunity to understand where the current law intersects with the future of artificial intelligence. This symposium contemplates the rights and the wrongs, some might argue, in the current state of artificial intelligence in our society. For our faculty, legislative, and community representatives that'll be here today, we're very pleased to provide this exchange of thoughts and perspectives as an academic resource as well. For those that may not be able to attend today, I'm pleased to advise the Washburn Law Journal will be devoting an entire issue to this symposium and the topic generally, and I want to thank those scholars here today who have agreed to write pieces for that issue as part of their involvement in this event. I want to specifically note that this event has been made possible by a generous endowment of the Robert J. Dole Center for Law and Government Fund. All of that said, I would now like to introduce Rachel Schwein, Editor-in-Chief of the Washburn Law Journal, to welcome you on behalf of the journal. Ms. Schwein.
Thank you. And thank you for joining us today for our symposium titled Artificial Rights. We began planning this event last spring, just as cases of COVID-19 began spreading rapidly. From the beginning, we were determined to hold this event, even if we could not hold it in person. I'm very thankful that each of our speakers agreed to join us today and that they were flexible and accommodating from the beginning. Although in some ways it is unfortunate that we cannot be together in person, the virtual platform allows people from across the nation to join us today that would otherwise not have been able to do so. I am pleased that all of you could join us for Washburn Law School's first virtual symposium. The idea for this symposium originated from the general interest from members of the Washburn Law Journal. Last year, several students chose to write about artificial intelligence when writing their note. From that starting point, we began exploring some areas of the law that involve artificial intelligence, and we realized that it is nearly everywhere. Criminal law, employment law, intellectual property, healthcare law, and government procurement, just to name a few. At the same time, there seems to be a lot of misconceptions about artificial intelligence and what the term actually means. Definitions of artificial intelligence are often vague or otherwise overly narrow. Perceptions of AI range from magical, almost superhuman portrayals in science fiction stories to merely a set of complex computer code. Today, we are pleased to have a variety of professors and practitioners joining us to present their thoughts and research regarding artificial intelligence. Our first panel is titled Machine Rights, and will explore the meaning of artificial intelligence and how it should be viewed, as well as how it should be regulated. Our keynote address is titled Machine Inventions, and will begin at 12:30 p.m. Central Time. This presentation will address the impact of artificial intelligence on the realm of patents. Our final panel is titled Machine Wrongs, and will explore the potential issues that result from artificial intelligence across several areas of the law. To begin our event, I would like to introduce the moderator for our first panel, Professor Patricia Judd. Professor Judd teaches many of the intellectual property courses at Washburn Law, drawing from her rich practice experiences in both domestic and international intellectual property regulation. We are very thankful for her support not only in preparing for this symposium, but also in reviewing many of the student notes that will be published in our upcoming Washburn Law Journal issues. I am very eager to hear the discussions led by Professor Judd. And so now I will turn it over for our first panel, Machine Rights.
Thank you, Rachel. That's a very kind introduction. And I just want to add my welcome to that from Dean Leisinger and from Rachel. This is a fantastic program that our students have put together, and I'm so pleased to be a part of it. As Rachel said, we will be discussing, my panelists and I, machine rights. And I just want to lay a little bit of the groundwork and then introduce the panelists and let them take it away. I think we have to start with the concept of what exactly is the machine. What is artificial intelligence? It's a concept that's not easy to pigeonhole. It's not a unitary concept per se. Comes in many forms on which I imagine that our panelists will elaborate. And so the full panoply of types of AI and its evolving nature create a number of difficulties as the law seeks to put appropriate regulations in place. And there are a lot of questions that we have to ask in order to ascertain how to regulate this beast. How do different types of AI relate to the humans who created them or contributed to their creation? How can AI work for the betterment of our society, for wonderful breakthroughs that otherwise would be a longer time coming? Which aspects of AI should we be concerned about when looking through a privacy lens or otherwise? And how should the evolution of AI cause us to reevaluate our current constructs when it comes to whether it be IP, healthcare law, criminal liability, or more? And so there are a number of things that there are to address. We can't possibly address them all in 2 hours or even a full day, but I love the group that our journal has put together for this discussion. And that group this morning includes 3 fantastic experts. I will introduce them now, and then without further ado, turn the mic over to them. We do have one expert, and that is Dr. Ryan Abbott, who has a bit of a conflict due to a time change. I believe he's joining us from London. So he will come up first, and we will do any questions and answers related to his presentation before he has to leave at 11 o'clock. And so I will introduce him first. Dr. Ryan Abbott teaches at the University of Surrey in the UK, where he serves as professor of law and health sciences. His published work on issues associated with law and technology, health law, and intellectual property law has been highly influential in both national and international circles. His insights are frequently in demand at the likes of the World Intellectual Property Organization, the World Trade Organization, and other government, industry, and academic fora. He has a recent book out, part of which I have had the pleasure of reading, entitled The Reasonable Robot, Artificial Intelligence in the Law, and I'm hoping he'll highlight some of that today. I will go ahead and introduce our other 2 speakers so that we can then seamlessly move from one speaker to another during the program. Second up will be Professor Brian Choi, who teaches at The Ohio State University, where he has a joint appointment with the Moritz College of Law and the Department of Computer Science and Engineering. He has an undergraduate degree in computer science and has extensive work experience in software development. And his research focuses on the question of how we make software safer for ordinary people, including exploration of software liability issues and data privacy issues. Our third speaker will be Dr. David Opderbeck, who teaches at Seton University, where he serves as professor of law and co-director of the Gibbons Institute of Law, Science, and Technology. His work focuses on intellectual property, cybersecurity, and technology law and policy. He also reaches out of the ivory tower, like our other 2 speakers, having recently partnered with the Bergen County Prosecutor's Office to conduct a series of programs and working groups on cybersecurity issues. His scholarly work also explores the relationships between law, theology, and science, with a recent focus on the emerging discipline of neurolaw. So each of our speakers will give their presentations, and then after Dr. Abbott speaks, we will take any questions for him. I would ask you please to use the blue raise hand function under the participants tab in Zoom, because we have several pages of participants here, so I can't always see a physical hand. So if you'd like to ask a question or offer a comment, please use that function. And I will keep the queue and call on participants so as to avoid confusion as to who has the floor at any given moment. So I look forward to hearing what each of these three has to say. And without further ado, I will turn the mic over to Dr. Abbott.
Well, thank you, Patricia, for that overly generous introduction, and it's a real honor to be here, and thanks so much to all of the students for inviting me. Everyone can see the pretty pictures? Hopefully. All right, good enough. Well, I've done two things in preparation of this event. One is I've written a book on the top, which I'm going to speak about. The impact of AI in 4 areas: tax, tort, IP, and criminal law. And to try and keep this to 20 minutes, I'm going to focus a bit on tax and IP. And the other thing was I screwed up the time change because England and the US have kind of different daylight saving times. And after 4 years, it makes no sense to me still. But the important thing to note from this, I think, is the importance of automation, because if I just done that through Outlook, the machines would have handled the whole thing seamlessly. So I like Patricia's focus on defining AI. My book starts with defining AI, and it's pretty remarkable, really, that 60 years after the term was introduced, we still don't have a good definition of it, or at least one that people widely accept. And it is a rather important sort of thing to do, to define your terms before you start trying to legislate around them. You know, and it is something in the IP area with AI right now where you have people really talking past each other because they're talking about different things. You know, I see AI very broadly and very functionally as, along with its earlier definition, if you see a machine doing something that a person doing would be intelligent in so doing, that would be intelligent. Well, that was a terrible definition off the cuff, which again just shows why we need to rely on AI. But basically, if a machine can do something that a human would do and that would be intelligent, that is machine intelligence or artificial intelligence. And what we're seeing now today is that, you know, AI has been able to do a lot of things that people can do for a long time, but it's getting better, cheaper, and faster at doing it. And this is getting to the point where we are likely in the next few years to start seeing AI taking over a greater number of tasks people used to do on a commercially relevant scale. So, you know, AI has been writing books and articles and making songs and short videos for a long time. They just used to be really, really bad. And now they're getting to the point where they're not so bad, to the point where for short things, you really can't tell the difference between something a machine wrote or a person wrote. And that really, I think, legally introduces a lot of changes to our system. I think the thing I found looking around at our legal system is, now that we have AI doing the sorts of things that only people used to do, when an AI does it, the behavior is often subject to a very different legal system than when a person does it. And this tends to have negative and unintended outcomes on the behavior, and it really stands in the way of the law achieving its underlying goals. So I think that the law should do less to distinguish between AI and human behavior, and I call this a principle of AI legal neutrality. And I think that if the law applied this principle, we get better social outcomes. Now, that is a bit different than giving AI rights. I think we have to kind of distinguish in AI rights between legal rights and moral rights. So, you know, there might be a reason to give an AI legal rights, and give all sorts of artificial person legal rights, mainly in the form of corporations and governments. But we don't give them legal rights because we think they're morally deserving of rights. We give them legal rights because we think they have the right sort of social outcomes. So we think that allowing corporations to enter into contracts is a good way to promote commerce and entrepreneurship. You know, there could be reasons to give AI per se legal rights. You know, for example, if you had a self-driving car that was really autonomous and it needed security in case it caused an accident, maybe it could have its own insurance policy, for example. And yet, as a practical matter, there's almost certainly much better ways of solving these problems, and we're not really to the point where it would make sense. But morally, even though an AI can act like a person, an AI is not like a person, and it doesn't morally deserve rights. So if we ever were to give AI rights, it would really just be because we think this has kind of a utilitarian benefit for people, and not as something to do for the AI. So I think a good way to look at how some of these things play out is in the context of particular types of law. And one of the types of law I want to talk about is tax, and the other is patents. And these are pretty much the two sexiest areas of the law, tax and patents. If you find yourself as a future practitioner working in one of these areas at a bar, like, yes, I do tax and patents, you're guaranteed to make friends. But in the tax context, this really plays into the future of work and automation. And this has been a subject that has waxed and waned in public consciousness since the first industrial revolution. It's a big part of the fourth industrial revolution. But there's basically two visions of the future. One in which the machines take our jobs and we don't have jobs to do. And the other is, well, the machines take some jobs, but those people find new jobs and we're all better off in the end. Historically, if you look at the past, the latter has happened. People thought machines would take all our jobs in agriculture. 40% of the workforce used to be in agriculture in the 19th century, and now it's 3%, but we don't have 30+% unemployment. These people have found new jobs. It's all worked out. Hasn't worked quite so well for some of the people who were displaced, who took a long time to find new work, but overall productivity has risen. Right. And so we may see that again in the future. We may see that, AI takes over driving cars or transcribing talks. And yes, that puts some people out of work, but they find new jobs and it's really okay. It might also be that AI is constantly getting better, cheaper, and faster, doing more and more, and people really aren't. And it's not too hard to imagine that in the next 20 years, we start automating segments of society where the people can't quickly transition into new job types. But one of the things that's not talked about too much in the automation future of work context is the impact of tax policy on this. And that should be a major feature of it because tax law treats behavior by machines and behavior by people very differently. So you may be used to going into McDonald's now and seeing automated cashiers or tellers. So you don't have to put your order in with a person, you can put your order in with a machine. Well, even though you have a machine essentially substituting for a person there, McDonald's has very different tax treatment of the machine versus the person. So McDonald's has to make payroll taxes for a human cashier, but not for an AI cashier, which means that even if the two are pretty much interchangeable and even pretty much the same cost, tax law is subsidizing the automation of that job. There are also other tax benefits that McDonald's gets, which are a little more complicated. It can accelerate tax deductions for capital investments and for certain sorts of software, and it avoids the indirect tax consequences of automation. And none of you probably want to hear about that too much, but it's in the book in painstaking detail. The point of the system for human work, AI work. And this produces some unintended outcomes when people and machines are in competition. And right now, where we are inefficiently subsidizing automation. It's a second problem because robots don't pay taxes, which sounds kind of ridiculous, but it sounds less ridiculous when you appreciate that 90% of federal tax revenue comes essentially from labor income. A large part of this comes from payroll taxes, and the rest of it comes from personal income taxes, which are largely labor income based. A relatively small portion, less than 10%, comes from corporate taxes. And so when McDonald's automates, not only do we lose those payroll taxes and the income taxes that the worker would have been paying, even if McDonald's does become more profitable there, and even if the profits were enough to offset those other losses, a relatively small amount of this is remitted as tax revenue. And so automation threatens our tax revenue, which is going to be a major problem if there is widespread automation. And even if there isn't, the standard sort of approach to dealing with people rendered technologically unemployed is to retrain them and provide more social benefits. And the government will have a hard time doing that without tax revenue. It may be a real issue as COVID drives further automation for pandemic-based reasons, but we have more unemployment, we have less revenue, we have GDP shrinking, and we have automation tax policies exacerbating some of these challenges. So what are some of the solutions to this? Well, you could tax robots. Taxing robots is a bit problematic for a number of reasons. Defining what a robot is, people and robots may not be one-to-one interchangeable. You'd have all sorts of administrative burdens associated with this. You'd have a lot of gamesmanship about it. You know, probably a better way is to create a more neutral tax system by eliminating taxes on human workers. So getting rid of payroll tax. That would make the decision to automate much more neutral to a company. So they wouldn't automate based on tax concerns. It would end taxation of something socially valuable, namely human labor. Does create some problems though with the fact you'd have to make that revenue up from somewhere. And there's a lot of places you could make it up. But this may be one way that thinking about the impact of AI on existing legal regimes is something that teaches us something about legal regimes more generally, right? So right now, the tax system is very in favor of taxing labor instead of capital. And it does this because it assumes that, you know, labor has to work one way or the other and it's not that mobile. But if we tax capital too much, people just aren't going to invest their money, or they're going to invest it outside of the country. You know, there's already a rich body of scholarship that really questions that assumption. There's a lot of reasons to invest in the US, regardless of its tax base. We have a very well-developed infrastructure and human resources. The Cayman Islands has a 0% corporate tax rate, but everyone's not rushing to invest their money over there. So it may be that even without AI in the system, we should be changing our tax base to focus more on capital than on labor. But this is something that we really should be doing and may need to do if AI comes to automate a substantial amount of labor. AI isn't just going to be automating cash registers at McDonald's. It is doing all sorts of creative and inventive things that people used to do. So we talked about AI making movies and music and songs, and AI has been doing this for really many decades. The difference now is that it's getting to a point where it looks like it's going to have substantial commercial value. You know, but AI is also inventing things. So people have been alleging for decades that AI has been inventing things, and it really matters here how you characterize invention or describe invention or what the machine's contribution is. You know, but at least in a number of instances, people have argued that a machine is generating patentable output without a person who traditionally qualifies as an inventor. And this raises a number of really interesting questions for patent law in the United States, where an inventor is generally required to have a patent. You know, can you have a patent if you have an invention without a traditional human inventor, or who might non-traditionally qualify as an inventor? Patent rights generally in the first instance go to someone who is the inventor, although as a practical matter, most inventors are under assignment obligations to their employers. So if you work for IBM and invent something there, IBM ends up owning your patent, but you are listed as the inventor. You know, so who or what, if this is protectable, would be listed as an inventor, and who or what would own an invention? To put this to the test, I led a group of patent attorneys who a couple of years ago, and your keynote speech is going to talk about this, filed for a couple of inventions by things made by an AI, right? And we say things made by an AI because it is a neural network that, you know, at its core has two neural networks, one of which is trained on data, corrupts the data it's been trained to, and then starts outputting novel data, and a second neural network which evaluates the data coming out of the first one for some criteria you're looking for, like novelty and inventiveness. You know, that was how the machine worked back in the 80s. Now it has thousands of neural networks working together, and each network represents a concept, and it combines simple into complex concepts. And it combined the idea of fractal geometry in a beverage container. So you could have a beverage container that looks a bit like a seashell. And the other is what we're calling a neural flame, which is a light that attracts in a certain way to attract human attention. You know, in both cases, the machine output these results. The person programming the machine said he hadn't been thinking about invention in either of these areas. He thought both of them were surprising. So we went ahead and filed these. We filed them in the UK and the EPO because they evaluated the applications without looking at inventorship. They essentially found that both were patentable. And then we corrected the applications by listing the AI as the inventor and the owner of the AI as the owner of the patent applications. And these applications are now pending in about a dozen jurisdictions worldwide. They've been rejected in the US, the UK, and in Europe, but all of those are under appeal. And we're going to see how the legal system treats AI-generated inventions or inventions made without a traditional human inventor. Now, we listed the AI not as a matter of providing rights to the AI, because the AI has no interest in being acknowledged. We listed the AI both to inform the public of the fact this was an AI-generated invention and to prevent someone from taking credit for work done by a machine. Because if IBM can get Watson, and I'm not picking on IBM here, to invent 1,000 things at the push of a button, and I could list myself as an inventor on all of them, we think that would devalue what it means to be a human inventor. And similarly, the AI would not own the patent. An AI wouldn't be motivated by incentives, wouldn't know what to do with a patent, couldn't legally hold it. The AI's owner would own the patent. And that is consistent with the way invention generally works with people, that someone's employer owns the intellectual property rights they generate in the course of employment. I'll speak a little bit more about that, but before this case, there was really very little law on it. There is more law on copyright. So in the UK in 1988, Parliament adopted a system to protect computer-generated works. So these are works defined as works generated by a computer without a traditional human author. And in those works, the producer of the work, like a film producer, is deemed, so legally fictionized essentially, to be the author of the work, and the author gets a limited term of protection. In the US, they've gone the opposite direction, really probably for a very long time, but at least since 1984, they've had a human authorship requirement. So this is based on case law from Burrough-Giles v. Cerrone, which I don't have time to talk about, but it's a 19th century case essentially holding that creative expressions that form in the mind of an author that are given expression are eligible for copyright protection. And the Copyright Office holds this to mean that machines can't think. Or monkeys. So this almost came up in litigation a few years ago when a monkey took its own photo. The owner of the camera tried to exert copyright in this, and the Copyright Office said, sorry, monkeys can't hold copyright. PETA sued the camera owner, alleging the monkey should own the copyright. And again, we're limited on time, so I won't talk about the case, but this was ultimately dismissed in standing in the Ninth Circuit. The court held Congress has to allow monkeys to have standing to sue, so the merits of the human authorship requirement were really never vetted. I think it is the right solution to allow AI-generated works to be protected, and this is mainly based on the incentive theory of patents. We have patents because we think certain sorts of innovations won't occur without them. And yes, it is true, machines have no interest in incentives, but the people who make and build and own machines care about incentives. And so allowing this sort of output to be protected will incentivize people to make, use, and develop AI capable of invention. And that will result in more innovation for everyone. It would also be a perverse sort of outcome if, for example, you had an AI that could make an antibody treatment to COVID, but a pharmaceutical company wouldn't want to use that AI because it couldn't get a patent and instead would have to rely on a team of human researchers. Not so much today, but in 10 years from now, it may well be the machine does a better job than the people in certain fields at inventing things. And it really wouldn't work well to have two different legal standards applying to both, and again, the robots wouldn't own the patents. That's one of the issues that AI and IP raise. Since these cases have emerged, and not taking any credit for the conversation, but the USPTO, the UK IPO, and WIPO, the US, the UK, and the UN's kind of IP agencies are having requests for public consultations about AI and IP. So it raises a lot of issues. One of the other interesting issues raised is the legal standard on which we evaluate granting patents, which is a hypothetical legal person having skill in the art. And this person essentially is kind of like the reasonable person in tort law. It is basically a fictionalized account of an average researcher in a field. I picked a picture of London commuters because I think they basically look like average researchers. This is the happiest you will ever see London commuters. It's really a very unpleasant process. But AI does some interesting things, even to average researchers, because even before you have AI really autonomously inventing without a person's inventive skill, AI is making people more knowledgeable because it is allowing people to have greater mastery of prior art. So they know more because they have access to AI that can help them find things. And it makes average researchers more sophisticated, because certain sorts of problem solving techniques they are adapting themselves, like having AI do pattern recognition and big data, but at a person's direction where AI is really just a tool. But it makes average researchers more sophisticated. And as AI keeps getting better and better and making average researchers more sophisticated, I think this should raise the standard for when we find something inventive. And at some point, AI is going to do this in really a very disruptive sort of way. So for example, if you think about monoclonal antibodies, and all of the best-selling biological drugs are monoclonal antibodies, these are basically antibodies which your body can make that target a particular pathogen. Now, the thing about antibodies from an inventive perspective is there's a limited number of them. I mean, there's a lot, like billions or maybe trillions, but there's really only so many ways that you can combine proteins together to get an antibody. And so it's not hard to imagine at all that you could have an AI that has every possible antibody sequenced, and publishing those antibodies sequences, if it was an anticipatory disclosure, could prevent people from getting patents on antibody compositions at all. It's not too hard to imagine also that you could have an AI that could do some modeling of which antibody works with what antigen, what drug-drug interactions is it likely to encounter, and so forth. And so you could have an AI in the future to which you present some novel pathogen like COVID-19, and it could say, this is the best antibody to treat that, and here is how you would formulate it. And if it did that, it would really wipe out an entire area on which people get patents. But you would have, the antibody-based cure to everything, so it wouldn't be so bad. When you have an AI taking over, though, from a standard researcher in an area like this, I think the AI is really effectively becoming the average researcher, and we may need to have a machine skill in the art standard instead of a person skilled in the art standard. And one of the really interesting things about this is, just as AI has been improving until now, the limits of its improvements may be, hard to put a limit on. That doesn't sound good, but you know what I mean, hockey stick graph, right? AI is getting better and better and better. People aren't. At some point, if we have this concept of super intelligent AI, which is the idea you'd have a machine that could do not only anything a person could do, which would be artificial general intelligence, but a much, much better job of it, including reprogramming itself to get better and better and better. There may be nothing that wouldn't be obvious to an AI, in which case there may be nothing that would get a patent. But I think that would also be all right then, because the cost of innovation would be so minimal, you wouldn't really need patents anymore. So those are a couple of ways in which the law treats behavior by a person and behavior by AI differently, why I think the outcomes aren't good, and why I think we ought to have a more neutral legal standard. And look forward to any questions you might have on it.
Thank you, Dr. Abbott. That was really interesting. I'm going to be on the lookout for blue hands in my participants' pane here to call on people, but I will exercise the moderator's privilege to ask the first question. And that is, one of the things I think that you perhaps especially offer among our panelists is the comparative view. Working in the UK, and you've done all of this work with the test cases in the various patent offices. And I'm curious to know, I was picking up on your discussion about, legal versus moral rights. And that made me think of the different theoretical constructs that we generally use. And all of that's an overgeneralization, of course, but the theoretical constructs that we generally use to justify IP protection, and how those constructs in some ways differ between, say, a US model and a European model. And so I'm curious to know what differences you've seen among the patent offices in their amenability to consider this concept of machine innovation, given those different approaches to protecting intellectual property in the first place.
No, it's a great question. I mean, I think the answer is much more developed on copyright, for example. So if you go to continental Europe, they're big believers in the idea that copyright really exists to protect the moral rights of all. Whereas in the US and the UK, people really tend to think, this is really a way for corporations to make a lot of money, or, the romantic version, someone, J.K. Rowling making a lot of money, but really companies. And, there is some ongoing debate really about whether the UK's protection of computer works even squares with the EU standards on which it needs an author's own intellectual creativity. But the UK is doing its best to kind of push off from Europe and get off its own way. On the patent front, we haven't seen that much. This is really a new issue for patent offices, and I think the next 10 years are going to be very instructive. In the UK patent office rejection, they had kind of a nice paragraph at the end saying basically, we're interpreting the law as we read it now, but we're not saying this should be the law, and there should be debate about this, and maybe the law should change, and they're having a consultation on it. So I think really comparatively open-minded. I gave a talk on this in Israel a few years ago before we announced the cases, and the response I got was kind of, we don't get the issue. And I said, why is that? And they said, well, you don't even have to disclose an inventor in Israel. We'd be fine with this. In China last year, a court granted 10-cent copyright over an article written by an AI. Judges in China have recently expressed the opinion they don't see a problem with doing this for a patent. So, I think opinions are changing quickly. I also think, there is an element of geopolitics to this and the AI global arms race. And at some point, countries that are big, that are seeking to be leaders in AI development are going to realize these sorts of policies are important for, domestic AI development, and also that there's all sorts of issues, kind of like access to medicines, with protecting these things in other countries. So, it's been nice to see WIPO taking a lead and trying to find some international ground. And, my prediction is over the next 5 to 10 years, some jurisdictions will accept the applications and some won't. And I would just finally add, and in the UK, we had a rejection from the High Court, and the High Court judge said, but I would have been inclined to accept this if you had deemed the owner of the machine the inventor on the basis of deemed inventorship, right? It's our position that isn't consistent with UK law. We wouldn't be consistent with US law, but, already people are going to go their own way.
Thank you. I've got Dr. Opderbeck in the queue.
Thanks. So I'll ask a cross-panel question, and good to see you, Ryan, and I really enjoyed this talk. So I actually have two kind of unrelated questions. One is about the tax issue, which is not my area of expertise. So I'll lay out both questions and then you can respond. But so the tax issue, in the US, payroll taxes fund the social safety net. So if we do away with or limit payroll taxes, or even if AI starts to replace the human workforce, that impacts the social safety net, which is already deeply, troubled. So you're kind of suggesting maybe do away with the payroll tax and tax capital, but then the question would be whether management would just pass that cost on to labor anyway in depressing wages and or to consumers. So I'm just curious how you think all that would work. And then on the IP side, as you're talking about copyright authorship as well as patent inventorship, I just have some kind of unformed questions about, for copyright, copyright term. I think we'd have to probably redefine a set term, obviously, that not life of the author plus 50 or something like that. And then we'd have to, I think in both areas, think about transfers and how do transfers happen and who has a right to determine whether there's going to be a transfer or not. So I'm curious about your thoughts on that.
Right. Well, let me answer the first tax question. Right. So I'm certainly not suggesting we get rid of payroll taxes and replace it with nothing. That wouldn't be good. And this does get to kind of basic normative distributive justice questions about, what do we want our tax system to look like? So there's a lot of things we could do. We could have a VAT, we could go up on marginal income tax rates, we could increase property taxes, we could, increase company taxes, we could do away with capital gains, preferential treatment, or stepped up basis rules. So, there are a lot of different ways to accommodate that. What I'm suggesting is that getting rid of payroll taxes would be valuable because it would level the playing field for AI and human workers. It's probably not a good tax even as it is, and inadequate to fund the safety net, and there are better ways of doing it. If we are asking for better ways of doing it, my personal preference is a more progressive sort of way of doing it, like I've laid out, or like taxing capital. But you could do it a bunch of different ways. Then there is an argument, it really doesn't matter how you tax, because at the end of the day, companies are just going to pass those taxes down to their workers, kind of like trickle down economics. And, you know, there is some extent to which I do think taxed parties pass on their costs, but I think it's pretty clear that it's not 100%, and that you're better off kind of taxing, you know, I want to come up with a term for cheapest cost avoider, but we'll skip that, right? Taxing a company, and to the extent they do need to pass some taxes onto their workers and their, you know, customers, you know, the market will work that out. As to the question of, you know, copyright term, right? You wouldn't want it to be indefinite for the life of a machine. You know, the way the UK does this is you have a 50-year term from creation of the work, right? And, you know, in copyright, I think the US is kind of a particularly sympathetic jurisdiction for this, given that they have corporate authorship and work for hire doctrines. And so, you know, one might then take a step back also and say, you know, 70 life years plus the life of the author is an awfully long time to have copyright. Maybe copyright shouldn't be that long now. And for a machine, maybe, you know, this is a chance for us not to give quite that much protection, leaving aside, you know, the challenges with changing the law and international treaties and so forth, which make it impractical. But, you know, you could have a shortened statutory copyright term for a AI generated work, or treat it like a corporate work for hire.
Professor Choi?
Hi, Ryan. So I have been following your work with interest, especially your tort work, and but I think this is the first time we've been on panel together. But I will also ask a cross-panel question, if I may. So I was especially interested by the sort of your AI neutrality principle, and so I just wanted to kind of ask, how far does that extend, and are there limiting principles? And the reason I kind of ask that is you analogize to the corporations, right? The corporations as persons, and there are limits though, right? And one of the limits is, for instance, in corporation context is the Fifth Amendment, right? Corporations can't assert Fifth Amendment rights. And part of the reason is, I think after an expansion where the courts were kind of willing to treat corporations as persons, they started to see some abuses. And so they kind of drew the line at criminal procedure. At the self-incrimination Fifth Amendment. So, and with AI, it reminds me somewhat of like the cyber literature that says, you know, the internet, there's some of the unique exceptional features are volume, speed, scope, right? The connectivity. And it strikes me that AI has some of these features too, that you would worry about sort of speed of production, for instance, or sort of the scope. And so are there any limiting principles, like why tax and patents and some of the other areas that you mentioned, is there something about those areas where you think the personhood label works particularly well versus other areas where you might sort of hesitate and say, not sure that I'd want to take it all the way there.
Well,
I guess maybe this is a longer discussion.
No. Well, I mean, it is a long answer, but I'm happy to give it. And great to be on a panel with you, though we have seen each other at a few conferences over the years. So that, so this is one of the reasons why. Hold on, look frozen. Is that me or you?
I believe it was you, Ryan.
Okay,
So if you want to just start again.
Okay, sorry. Well, let me just answer that by saying, you know, this is one of the reasons I focus on criminal law in the book. And also, I think there's a lot to be explored with how this applies in different areas of the law. You know, with things like tax and patents and torts, you know, I take a fairly utilitarian view of what we're looking for out of those bodies of law. Like with torts, you know, we want to promote safety, and, you know, we want a lot of other things. And with taxes, we want to encourage certain sorts of behavior. And with patents, we want to encourage innovation. You know, criminal law strikes me as the law that is least like that, where we care not only about prohibiting antisocial behavior, but we really care about why someone has done something. So culpability and retribution are really kind of fundamental principles of criminal law. You know, I don't just care that you ran me over, which might also be a tort. I care that you wanted to run me over, or at least you were reckless as to running me over. And, you know, I ask in that context whether it makes any sense to say, hold an AI liable for committing a crime. And I think, you know, once again, it's not as ridiculous as it seems, because we do hold corporations liable for committing crimes. And you have strict liability crimes where you can have liability for, without a mental state. And you can even have liability for crimes based on an omission to act where there is a duty to act. So holding an artificial person liable for a crime on the basis of not doing an activity without any mental state is not as, crazy as a departure as it seems. And there could be benefits to doing that too, like expressive benefits. If there was a self-driving Tesla that started running over investment bankers, saying to those investment bankers, we won't tolerate this kind of behavior no matter what commits it. If we destroyed this car, that might have a punitive, that might impact Tesla's behavior and so forth. But I think kind of as with corporations, there's a lot of cost to doing something like that. Even leaving aside radical legal changes that change people's perception of the law and cause disruption, I still can't think of really a good reason why you would want to give an AI, rights per se. For any example that someone could offer as to, kind of the consequentialist benefits of doing it, I can find kind of an easier, simpler, better solution of not doing it. But I do think that even in criminal law, where you really care about deontological reasons for doing things, punishing an AI isn't inconsistent with underlying criminal law theories in a way that, the law couldn't make more legal fictions around, or in a way that would really prevent the law from, functioning effectively. And so I just sort of started talking for a long time, and then I'm trying to come back to your original question and to answer it succinctly. And so the answer is yes. I mean, I do think there are a lot of costs associated with creating rights for things like corporations and AI, and that on the other hand, I don't think that rights for these sorts of things are fundamentally incompatible with the law. And if there was a good reason for doing it, one could narrowly have rights and obligations for AI, right? Which might just consist of obligations. And, you wouldn't, want to let AI that isn't kind of futuristic, strong AI vote or get married or do that sort of stuff. But things like having insurance policies, I think there could be a case for that.
Professor Troy, I want to let you respond, but I maybe will ask you to do that during your talk. We are starting to run a little low on time, and we do have a question from the one participant. And so I've gotten a question by text from Clayton Pummel, who says, apologies, but doesn't have mic and video. Clayton is interested in your perspective on whether the European framework on ethical aspects of artificial intelligence, robotics, and related technologies, I suppose the report issued 9/28, will lead to a GDPR style regulation of ML and AI? And if so, do we know what that will look like? Or is there other legislation pending on the issue?
Well, it is true. I was on one of the European Commission expert groups kind of on this, and I do keep generally track of it, but I am not the right person to ask kind of on the nuance of the EU doing this. I mean, I think the EU has taken a great interest, or the European Commission has taken a great interest in the regulatory framework for AI and machine learning. I think they're aware of many of the issues. A lot of this is really very decisive still, though. And I think they are probably at a point of kind of principles still, that probably a little ways from, having a detailed GDPR level body of regulation. But I do think that is on the horizon, in the next 5 years, and certainly something to follow.
Thank you so much, Dr. Abbott. I think we'll wrap up your presentation. Clayton says, thank you, appreciated the talk. And that was fascinating, and we appreciate your participation. I will
Thanks so much for having me.
Throw it back to Professor Choi, who graciously stepped aside from the first slot to allow Dr. Abbott to go first since he needed to leave early. And so Professor Choi, over to you.
Wonderful. Thanks so much, Professor Judd. And thanks also to Dean Leisinger and Rachel Schwein and Washburn Law Journal. Just thank you for hosting this event. And I'm thrilled to be part of this discussion. So I'm going to talk a bit about, AI as a from the technical standpoint, right? So when thinking about the legal rights and responsibilities of AI systems, I first want to say, I think there are two broad approaches one can take, right? And the first is to treat AI as a black box entity. And the second is to open up the black box and focus on the people and processes involved in developing those AI systems, right, behind the curtain. And so far, I think the black box approach seems to have captured more of the popular imagination. But the argument I want to build this morning is that the second approach is preferable. And then I'll talk about how that might work in the context of deep machine learning, which, we talked about how to define AI, but I think deep learning, deep neural networks is really the main form of AI that's being used in real world situations. Okay, so the merit of the black box approach, I'll talk about the merits first and some of the problems, and then why I want to argue for the alternate approach. So the merit is that it avoids having to scrutinize technological complexities, right? You say it's a black box, there it is. You don't have to unwrap it and look at how the sausage is made. So, for example, many commentators, including present company, I like to analogize AI to persons or perhaps sentient beings, just children or animals. It just depends on how sophisticated you think that AI is. And our legal system is already set up to deal with people. So you think this would be an easy fix, right? We wouldn't have to change that much about the legal system, just redefine the term person to include AI. And if we already do that for corporations, well, why not other artificial entities, right? And you can talk about whether that's a comprehensive or a more limited definition. Now, other commentators also suggest on the other side of it, on the liability side, that perhaps we should use enterprise liability or strict liability as a simplified way of handling the liability questions. And again, this is a way of avoiding the messy concepts like intent or reasonableness. And you can just ask the causation question, right? Just say, was someone hurt by AI? If so, then that person should be compensated and made whole. And you don't have to potentially have to dig into the details of whether there was a reason why that harm occurred, whether that was reasonable or not. Now, the downside of the black box approach, so if the upside is that you can avoid these technological complexities, I think the downside is also that it encourages kind of a flat tendency to swing between extreme optimism and extreme pessimism about these new technologies, right? It doesn't require us to explain or understand how the technology actually works. So for example, if you're focused on the intelligence part of artificial intelligence, right? There's two parts here. If you're focused on the intelligence part, that probably means you're gonna wanna talk about how well AI will work, right? You get very excited about how much better autonomous vehicles are gonna be than human drivers, or how much better AI-based medicine is going to be than human doctors, right? It's so intelligent that we can replace humans with AI. And often the legal analysis will start with something like, well, assume that the AI system's performance is twice as good as human performance, or 10 times as good as human performance. Or if you're talking about IP authorship or inventorship, it's that human creativity is just a weak imitation of what infinite robotic combinatorics could achieve. Right. And so if you tend to think that artificial intelligence is better than human intelligence, you'd be more likely to favor broad immunities and protections for AI so that we can incentivize greater innovation or greater production of this benefit, right? The societal benefit. Okay. On the other hand, if you're more focused on the artificial part of artificial intelligence, that it's ultimately a human-made creation, then you might expect to hear more about how AI is flawed, untrustworthy, that it's never going to be good enough to replace humans. So for example, this comes up in the context of policing and criminal justice. So even if human judges and decision makers are flawed, we carry our own biases. Well, AI is also flawed and biased because, well, AI is made by humans, right? And so the biases that we have are embedded in the AI systems. And so how could we trust the AI if it's just going to be, an extension of ourselves, right? So it will be just as bad or worse than humans. And in fact, by creating this dangerous thing and bringing it into the world, the AI developer is a bit like Dr. Frankenstein and should bear full responsibility for any risks created by their dangerous creation. And so then you'd be more likely to favor harsher approaches, right? Something like strict liability or enterprise liability that deter and limit the use of AI, right? Now, often people will say that we need these black box approaches because AI is inscrutable or opaque. Explainability is a challenge. So even AI experts will say, well, we don't really know how to properly explain in human understandable terms why an AI system chose one particular decision over another one, right? And that's all fair, but I actually think it's a bit of a distraction, right? So I think that we can focus greater scrutiny on the AI developers who do the work of building AI systems and not just the effects of that AI systems have or the decisions that are outputted from the model that is built for the AI. And so this is the second approach that I talked about at the start, right? Instead of focusing on the black box, let's focus on the people and the processes behind the black box. And the reasons to do this, I think, are twofold, at least. One is that I think it gets more directly at which aspects of AI development might be easy versus which ones are hard. And two, you then avoid some of the temptations to blame the machine or to blame the users of the machine, what Madeline Eilish has cleverly called the moral crumple zone, right? I think we want to take the attention, put the attention back on the developers who might actually be able to do something differently as they are developing or building this AI system. And I think we do want to hold those people responsibility. I think it, Felix Cohen has called, the definition of person when we call something a person, a bit of transcendental nonsense, and I think that applies to AI too. It's not about whether AI is or is not a person, right? The question is, should we hold responsible the AI developer for that they should have been able to do something better or not? And so for the remainder of my remarks, I want to come back to this question of which aspects of AI development are easy and which aspects are hard. And I want to be clear again that when I'm talking about AI work, I'm really focused specifically on deep neural networks, which in the last 10 years has become the dominant approach to AI, just because it just works orders of magnitude better than sort of the classical AI techniques. And other kinds of, I guess there are other data-based approaches, advanced analytics, that might fall within a sort of subcategory of this, but I'm really focused on sort of the deep neural networks that are built on large swaths of data. Okay, and if you look at this kind of deep AI work, I think you can divide it into three components. There's the data, there's the algorithm, and the testing, and I'm going to talk a little bit about each one, but the high-level takeaway that I want to sort of emphasize is that developing deep AI is quite different from developing conventional software, and that most of the hard judgment calls here are in the data aspects. Almost none of it is in the, I would say, in the algorithmic or the code aspects. Not that there aren't judgment calls to be made, but that I think the really hard judgment calls are in the data aspects. Okay, so data, algorithm, and testing, and I'll start with the data. To build a deep neural network, you need training data, you need lots of it. So you can think of AI training kind of like sculpting a statue out of a big block of marble. And if you think of each piece of data as being like a single chisel cut, that helps shape that marble, right? So if you have a single example, you're making a single cut into that original block of marble. And the more data you have, the more fine-tuned that sculpture will get, the more it'll start to look like the final thing you want. And the less data that you have, the rougher it will look, right? Maybe one side will look pretty good if you only look at it from that one side, but then you turn it around and another side is just completely janky, right? It just wasn't finished, or in fact, it was marred in some flawed way, right? And deep AI experts will say that if you have a large enough training data set, this is so important that in fact dwarfs pretty much every other decision that they can make, right? At the point where you have enough data, it doesn't really matter whether you're picking one algorithm or another algorithm, or whether you're tuning the algorithm in certain ways. In fact, having a large enough training data set is probably the most important aspect of your training, of your development exercise. So a rough rule of thumb is that a minimum of about 10 million labeled examples will help you achieve human level performance. But of course, many systems have far more than that. That's just sort of a basic minimum rule of thumb. Google Waymo recently released an open database with 20 million miles of on-road experience with a catalog of billions of labeled objects. GPT-3 had more. Those were unlabeled examples. And that's still probably not enough, right? It's still not quite ideal. But you're getting the order of magnitude of data that you need in order to achieve that kind of performance. Now, the hardest challenge is that you need labeled data, at least given current sort of state-of-the-art technology. So you need labeled data, not raw data. So for example, just a sort of a toy example, if you're trying to just teach the AI model how to distinguish dog images from cat images, right, you'll need to label each image in the data set as dog or cat or some other value. And going back to that sculpture analogy, you can think of the label as telling the algorithm how to make each cut, how to angle the chisel and how hard to hit it. If enough of the labels are wrong, right, you might end up actually carving the wrong shape. So getting the labels right is actually important. It's quite hard. There's a lot of subjectivity to it. How do you choose the labeling scheme? And are you getting it right? Mistakes? Are there perhaps just messiness or noise in the data that's causing distortions? As a result of that need to label the data, you run into another big problem, which is that there aren't nearly enough labeled examples. And so, for the most part, if you don't have enough examples, you have to come up with a variety of tricks to try to boost the ability of the AI learning algorithm to learn from these smaller data sets. And there's a variety of ways to augment the data set or to try to use other tricks to sort of extract more information. So, if you have an image, you can rotate it, or you can flip it, or you can, do a variety of manipulations, and you can do other kinds of tricks to this data so that it looks like you have much more data than you started with. But, many of these tricks are still pretty new. They're still evolving. They're still state of the art. And so this is kind of where the bleeding edge of this research is happening. So there aren't still good norms or practices yet around what you should be doing or what you shouldn't be doing in this aspect of the whole development process. And so I'd say those are at least two of the hardest problems for AI developers: is badly labeled data and insufficient data. And these are closely related problems. There is a third type of category where you're saying that the data should just be completely verboten, right? It's illegitimate data. And in a couple of examples of this might be what Professor Judd referred to. Privacy might be one reason, right? So it might be that it's too personal, that it's your face, right? Facial recognition, or it could be deep fakes, right? There are certain kinds of uses of AI where you say like that kind of data is not good. We don't want to allow it at all. And then a second kind of example might be bias. And again, in policing and criminal data, that's been a particular issue where you say the data that you start with is so biased, there's no way to salvage it, and we should just not use this data at all. But that kind of problem is sort of a prior problem, right? It doesn't have anything to do with how the work is being done, how the AI developer does their work. It's a sort of from the beginning, there was no way that they could have possibly fixed this data. We just think that it's objectionable from the start. But that's at least a third potential category of problem with the data. Okay, well, what about the other two components, algorithm and testing? And here I would actually argue that there are more well-established practices. So it's actually much easier to tell whether someone is following good practices or not. For example, there are a range of learning algorithms you could pick, but folks have a rough sense of which algorithms work well with which tasks. So if you're taking, for instance, an image recognition task, right, there are certain algorithms that seem to work better for image recognition. And there are different ones that work better for, say, text generation. And so if you were to switch up the algorithms, it's not like someone would say you're doing something wrong per se. Of course, you're free to experiment and try to achieve better results. But you might say, wow, like that was pretty unusual or unexpected, right? I would have thought that this other approach would have worked better, right? That's the more standard approach. And so there are some developing norms around this. I should also add that the code for these algorithms is on the relatively small side. They're often available as free software packages. They've been debugged, they've been sort of poured over, and generally you're just taking off-the-shelf packages. You're not developing your own algorithms from scratch. And so that I think lends a different kind of thing versus conventional software development, where you have to write it all from scratch, and you might make various mistakes along the way. So I would say with this kind of deep learning, the special sauce is really the data. It's not the code. So that's where the focus should really be. Okay, finally, what about testing the AI model? And here too, I think there are some common best practices. Right? So typically you partition your data into a training set and a test set. Right? And a good rule of thumb is around 50 to 80% would be training data, and then the balance would be test data, and it really depends on how much data you start with. But you run your test data through your AI model. Like you've trained it up, right? You have a model, and you just want to test to see how well is it performing. And you get a percentage number of how accurate that AI model is. Now that gives you a benchmark that you can compare against others who are also working on the same problem. That's not to say that it's perfect, right? Just because you're getting 100% doesn't mean that the test data is comprehensive. The test data might have blind spots. Certainly if you take it out into the real world, doesn't mean that having 100% on the test data means you're gonna get perfect performance in the real world. But the point is that it does give you this number that lets you compare one AI model to another. And if you're getting, say, 30% accuracy, right, that's a strong red flag that says you're doing something wrong. And then if you have two AI systems that both claim to perform at 99% accuracy, well, you can go compare their test sets and see how similar or different they are. Right? This is a different kind of testing than you would find in the conventional software context. I think in the conventional software context, you try to have these benchmarks, but they're much more imperfect. There's much more art to trying to figure out how to do that kind of testing. Okay, so I'm getting towards the end of my remarks, and I just want to close by zooming back out and returning to the main question of how to handle the legal rights and responsibilities of AI systems. And the reason I've focused in on the technical details of this work that AI developers are doing is because I think courts and regulators would likely be able to get significant mileage out of doing that, right, in terms of improving and standardizing AI development practices. And I've tried to also draw this distinction. I think that AI development is likely different than conventional software development. I do have a piece that came out just this past spring called Software as a Profession, where I try to argue that software developers should be treated like doctors and lawyers because software work involves a lot of the same difficult judgment calls that doctors and lawyers have to make with a high degree of risk that things are going to go badly. And if that's true, then one possible framework for software development and possibly for AI development would be this professional malpractice model. And I'm happy to talk more about that in the Q&A, but I don't want to dwell on it right now. But that's one model, the professional malpractice model. It's also possible that AI is different, that it's easier to regulate, and that we would be comfortable doing a more familiar negligence or negligence-like approach to AI work. But either way, right? Either way, whatever approach you do take, I think that the main point I want to emphasize is that I think it's crucial to focus on the AI developer, not the AI system or the AI user, and that's probably a good note to end on. To focus on the AI developer and the work that they're doing. Okay.
Thank you so
Thanks
much, Professor Choi. So interesting. I will, again, look for blue hands while exercising my privilege to ask the first question. And I'm going to bring you back to what you just said you didn't want to dwell on, because that was the question that was on my mind. I read your Harvard Jolt article with interest, and you brought up last night, actually, in the breakout room, this concept of sort of a fiduciary relationship that could be created between, say, the software developer and others. And so I was curious to know, that was the question that was on my mind throughout your presentation, was you kept making reference, of course, to the differences between conventional software development and AI and certain types of AI development. And I'm interested to know how much that theory of creating a potential fiduciary relationship or a professional malpractice standard would translate into this context in your view.
Yeah, okay, so I'll take a stab at it. In the software as a profession piece, what I was trying to articulate was, why do we treat doctors and lawyers differently than non-professionals? Why do we have this separate category? And it wasn't actually clear to me, even going back and reading the literature. So the main distinction seems to be that you treat doctors and lawyers to a customary care standard rather than a reasonable care standard. For some reason, we allow doctors and lawyers to be more self-regulating. You judge them by this custom standard. There's a range of a behavior or decisions or judgments that are acceptable. You can have a majority view and a minority view as to, so for instance, if you're dealing with a patient who has cancer, right? There might be a majority view about what kind of treatment you should take, and there might be a minority view. And the reason that those are acceptable is because we don't really know, right? We don't actually know what the single best way to treat a patient like that might be. And so rather than hold the doctor liable for giving a subpar treatment, you say, well, there's a range, and as long as it's within this range, as long as it's within the custom of the profession, we're going to say that that was acceptable and okay. And the argument I make in the paper is that software is a bit like this too, that it's just so hard. There's it's not, and it doesn't follow some kind of natural order the way that, say, building a bridge would, or other kinds of, like if you go to the barber and you get a haircut, we generally have an idea of what a good job is, or even driving on the highway, we have a general sense of what good driving looks like. But with software development, we don't have actually a very good idea of that. Yeah, there's some, some general practices that, but as a whole, there's just so much complexity there, and it's a bit, it's not causally tied in the same way that, say, building a building might be. So on that basis, I think software development should be treated differently, a little bit like more in the professional category. And then the question is whether AI falls into that same camp. If you could say that AI development is just so, non-determinative, I guess, that there's just no good guidelines. You can't judge good AI development work. Then I think maybe it does fit into that same kind of category, right? And you say it's socially valuable, it's something that we can't live without, the way that we can't live without software, then perhaps that would be also reason to give more deference, I guess, to AI expertise. But if you think that there are ways to second guess, right, to say we know how to do what good AI work looks like, and boy, you really didn't follow that, right? You didn't use enough data, for instance, or the way that you massaged that data was bad, or that your choice of algorithms was bad, or you didn't do enough testing, or something along those lines. Then, if courts are comfortable doing that, I think we should apply a regular negligence or negligence-like rule. Or we could even have regulators come in and do that kind of second guessing. But either way, the point I want to again emphasize is I think we should be doing that kind of inspection of the work, right? The work that that AI developers are doing, not just treating it as a black box and saying, don't look at the work that that is involved in building that black box.
I don't want to jump the line, but there is a comment related to this discussion in the chat, and I just wanted to read that out. And that's from Professor Burt Griggs, one of my colleagues here at Washburn. And he gives the analogy to architects. And he's like, in addition to doctors and lawyers, we have a great deal of exposure for personal liability on the part of architects. And so he was just, positing the question, is someone who designs an AI system more analogous to an architect? And he just says that his internet is not great right now, so couldn't offer the comment / ask the question himself. I don't know if you want to respond to that briefly.
Yeah, sure. I'll respond very briefly. So I do talk about architects in the paper, in the prior paper, and what I find, again, architects have traditionally, there is case law saying that architects are professionals, but there's also more recent case law that questions it, or at least seems to give less deference to architects, right? The custom of architects doesn't seem to govern whether or not courts are willing to apply liability. And my theory of this is that we know more about how to do good architecture now, right? It's less of an uncertain science or inexact science. We know better how to do that. And so maybe courts are more willing to second guess architecture. And so maybe that's a way in which, with AI too, if we get more knowledge or get more expertise and things start to be more certain, maybe that would be a similar kind of exercise too.
Thank you. I've got Professor Rubenstein in the queue.
Hi, thank you, Professor Troy. That was really fascinating. I'm looking forward to reading your article. I have it pulled up here. I haven't yet. So I have a question about sort of what you had in scope during your talk, and perhaps your paper sort of hits I guess the bookends on both sides, which to me, I had questions about. So you sort of picked up with data, and my question is, before you get to the data, you have to select the problem. You have to decide what it is that you're going to optimize for. And I'm wondering if you think that how that would factor into or feature into your framework for like professional malpractice, like just choosing the problem set that you're going to use AI for. That's on the front end. Then on the back end, with regard to how the AI system actually operates in the real world. You know, as you noted, these things, when they go into the wild, because they interact with other systems, and what is the developer's responsibility for negligence or other types of liability in that kind of context. And also, like, these development teams and the AI technologies could also be joined together. They're interoperable in many ways. So if you have like a handoff from an algorithm that gets then put into another algorithm where everybody individually is acting appropriately, but you have the system effects when you put all together, what emerges is a really terrible, awful system. How do you account for those types of things? And then my last question is with regard to testing and benchmarking. I mean, obviously, I think that you were directed your comments at like performance and accuracy, but what about choosing which fairness metrics, you know, which of the 21, or I'm losing count, how many definitions of fairness there are, and those types of choices and that type of testing. So you're not just testing for accuracy, but some of the social impacts that these technologies will have in the real world.
Yeah, those are all terrific questions. And I think you're laying out my research agenda for the next, I don't know, however many years.
He's frozen, or is it me?
You overwhelmed him, David.
And I was about to tell him he had 4 minutes to answer all of those questions. So
well, we are talking about technology today, so I guess it's appropriate.
It was a pretty bad question anyway. It's okay. We don't.
So what I might suggest
for that research agenda, just
what I might suggest we do, if Professor Choi doesn't make himself heard in the next, minute or so, is I think he has just left, perhaps to rejoin. So Dr. Opderbeck, perhaps we move on to your conversation, and then we can follow up on Professor Rubenstein's question during the general Q&A.
all right, sounds good. And I'm going to share my screen and just pull this out a little bit here. Okay. So, I think we've been in this panel so far, kind of looking at a big picture, zooming in on some details of development, and I'm going to kind of zoom out again to a big picture question, which really interests me in this idea of virtual rights. And what I'm going to present to you is related to kind of a trend in jurisprudential thought of thinking about whether and how virtue ethics might fit into our ideas about jurisprudence. And I'm going to try to tie that a little bit into our questions about artificial rights. So, we can kind of, I'll go quickly through this, but if we think about modern theories of where rights come from, and generally these are human rights, but as we'll see, they extend to things like corporations. But, why do we have rights and where do rights come from? We have kind of social contract theory, and there are embedded in that kind of theory some ideas about what human nature is and where humans come from and why we need law to govern us. There are theories about will and autonomy. And again, these also embed ideas about human nature and the possibility for autonomy and agency of human beings. And then there are theories about interests. And this is the notion that human rights are going to secure in some way some things that are necessary for human beings to lead a minimally good life. And you can kind of map those out onto the main sorts of ethical theories that feed into the way we talk about, most people talk about rights today. So I'm just going to put my pen on for a sec. So we have, our deontological categories. There are rules, and those tend to be based on the status of the actor as an agent who's capable of some degree of autonomy. I'm going to go over here for a sec first. We have contractual ideas and social contract type ideas, and those tend to be based on the ability of the actors to make rational choices about what would be in their own self-interest. And you can get to things like Rawls's veil of ignorance and making that choice for everyone. And then we kind of have in the middle, I lost my pen here, we have consequentialist theories. And those are instrumental theories, and there's some notion of what social welfare is, and you're just going to try and move toward something that will maximize that notion. So I think these modern ideas of rights present a bunch of problems when we're talking about something like artificial rights. And I think, Brian kind of was touching on this before. A lot of the discussions that we have, that we have in the literature about artificial rights, don't always do a good job of teasing out weak AI and strong AI, which is a term some people in the field use, some people don't like. But what we've been kind of talking about, neural networks and deep learning and the kind of AI that really exists today, we can kind of put in this category of weak AI, which doesn't mean it's literally weak. It's incredibly powerful. It's just a conceptual idea. Strong AI is kind of, when you saw Ryan's graph with that hockey stick, and he had up there that bullet of the singularity, right? So strong AI is this idea that at some point, AI gets to the point, not only that it can do things that are even better than humans can do them, but that it has some kind of self-awareness or some kind of other aspect of agency in which we might consider it its own agent. And theorists in this area and philosophers that deal with this area speculate and differ about whether strong AI will ever even be possible, and if it is possible, when it might happen. So the discussions kind of about artificial rights, in some ways, I think, unhelpfully don't tease out these concepts. I think it's really important to do so. All of these discussions, I think, do raise really big questions about human nature and metaphysics. And I'm one of the people that doesn't think this is just transcendental nonsense. I think this is actually fundamental to the discussion. And I'll just give you a couple of examples. I won't read them all, but this is Chopra, Samir, and White, a really interesting book on a legal theory for artificial agents. And their overall point about it is people object and say, well, it's just a machine. And they suggest, well, neuroscience tells us that we as human beings are really just biological machines. That's an enormously loaded metaphysical statement. By no means is it established in the philosophy of mind, which is its own big field, but it's a big question to ask. Another one, and I'll come back to this piece on, just going to set my timer. I'll come back to this piece on the First Amendment in a little bit. So this was a really interesting article by Massaro, Norton, and Kaminsky on the First Amendment in artificial intelligence and whether we want to give artificial intelligence agents First Amendment rights. And so they note, if we're going to make an argument about speaker autonomy as a basis for First Amendment rights, we have to talk about moral personhood and what that means. They first suggest that notion of moral personhood, the gap between the human and the machine, is already closing and will continue to close. This is actually one place where I think, as a critique of this really interesting article, what does that mean? Are we talking about neural networks and weak AI, or are we talking about closing to the point of strong AI? I think that's a big question. But then they also raise this normative question: should moral personhood matter to a fundamental right, like a free speech right? And I think really the kind of the philosophical problem that they're addressing there is ought problem. Is the fact, even if we can identify something like human nature as opposed to a machine nature or something like that, does that confer an ought of some kind of prescription or right about First Amendment speech rights? And I think they're expressing a degree of skepticism about that, which again, I would respond to and not be as skeptical about it. But these are issues I think that we need to kind of surface and flag in any discussion about artificial rights. I would actually suggest, in addition to the kind of problem of not teasing out strong and weak AI, all of these existing theories that we tend to use in the modern period for justifying rights are really flummoxed by what we might mean by artificial rights. And I'm gonna, with apologies to Alistair McIntyre, and if you don't recognize the reference, he has a book called Whose Justice, Which Rationality? So I'm gonna say whose rules and which consequences, whether it's deontological, contractual, or consequentialist when we're thinking about AI rights. So again, kind of coming back to this map, and this is much oversimplified, and I hope to kind of develop it in writing in the paper, but deontological status-based, the kind of core question, I think, is what is the status of whatever AI system we're talking about? Does it possess any sort of status that we might suggest comes with legal rights? When we look at the instrumental question, we're going to say, does the provision of some kind of right to the AI system maximize utility? I think that's what Ryan was kind of talking about. And again, I'll come back to that. Some questions I have about that in a little bit. And then for the social contract, is an AI system capable of making rational choices about contractual like social relations? And I put rational in scare quotes because in the philosophical literature, there's a huge debate about what does rational even mean, if it even means anything. A lot of people in writing about artificial rights tend to use a kind of minimal definition of rationality, which is basically that there's an end and that the actor is capable of making some kind of decision towards that end. And again, that's a contested notion and a notion that I think I would probably contest. Another piece of AI rights that I think is not often well explored is the relationship between rights and something that I think Brian was kind of touching on, which is responsible AI principles. Some of these, most of these ideas about transparency and fairness and accountability are all about what we think responsible AI should be. And there's a lot of great work that's being done, both in the industry and in the academy, about how we should think about the responsible development and use of AI and what that should look like. And those high level principles, presumably then would filter into something like the things Brian was talking about. Actually, as you were talking, Brian, I was thinking, in the privacy field, there's a big development of privacy by design. That's the new thing. So part of what you're talking about is, some kind of responsibility by design in AI, which I think makes a lot of sense. But if you look at some of these principles when we talk about rights, so I'm just going to use the Asilomar principles, which is one set of influential principles that people look to. There are other sets that, things you can look to. And most of these tend to coalesce around the same core things. And again, the Asilomar principles does make some effort to tease out sort of weak AI and strong AI, but what they're trying to address is what principles do we want to think about now in the event strong AI is ever going to be possible, because if it is ever possible and it happens, there's no going back. So it's a useful thing to think about now, even if you think philosophically or otherwise, maybe it's not possible, or maybe it's, many decades out. But all of these things, these systems should be designed so that their goals and behaviors align with human values. AI systems should be designed so as to be compatible with human dignity, rights, freedoms, and cultural diversity. And this is really the strongest ones. Human control. Humans should choose how and whether to delegate decisions to AI systems to accomplish human-chosen objectives. When I teach a seminar in AI and law and policy, we spend some time talking about this one, because if strong AI is truly possible, what you're saying in this principle is that the strong AI needs to remain the servant of humans. That's a big question, right? It's a big argument. And even if we're not talking about strong AI, even if we're talking about incredibly powerful weak AI, if we're using the language of rights, we're really potentially raising conflicts with some of these other principles that we're suggesting are really responsible AI principles. So I don't have a solution to all this, and I'm not going to suggest that virtue jurisprudence or virtue ethics supplies the solution, but I being generally interested and attracted to this school of thought, I want to explain it a little bit and then suggest some ways in which I think it might be fruitful for a fruitful piece of this overall discussion about artificial rights. So virtue jurisprudence is related to virtue ethics, which, if you noticed on the first splash slide that I had, I had the sort of robot thing, and I had Aristotle. So this is a deep strain of ethical thought in the Western philosophical tradition, going back to Plato and to Aristotle and to the whole Western tradition going forward. And the notion is that ethics is about the cultivation of virtue and not about specific rules. And so if we're thinking about how that might apply to law, and there's a growing school of thought in virtue jurisprudence, which is that law is also, because it's part of human society, about the cultivation of virtues that are essential to human flourishing. And a few pieces about it. Virtue ethics and virtue jurisprudence is teleological, as all Aristotelian thought is teleological. It doesn't view sort of human nature and human society as fundamentally and completely undetermined, but it views human nature and human society as always sort of moving toward some goal, the goal being human flourishing. As I mentioned before, it's principle-driven rather than rule-driven. So it's not giving specific deontological rules that apply in specific circumstances, but general principles that then can be brought into specific circumstances. And I think this is important, it tends to be more communitarian. So it's not, even in terms of thinking about rights, and this is actually a lot of piece of work that virtue jurisprudence is doing and has to do. How does this relate to individual rights? Because the focus is not on the individual, the focus is on the good society and how the good society in which individuals can flourish, because individuals don't ever exist outside of community and society, how that can be developed. So those are just some pieces. It's a big research project, and you can find books and other things on it. It is related, virtue jurisprudence, in a really interesting way. And Patricia, in the little brief bio that I gave, kind of mentions my interest in law and neurosciences, which is really how I backed into this whole area. So it's related to a bigger movement in analytic philosophy generally, and in the philosophy of science, in the analytic philosophy of science, that is retrieving Aristotelian philosophy, and they're calling it neo-Aristotelian because, one of the questions I would anticipate, there's a lot of things in, the ancient versions of this that are not acceptable to us today, and rightly so. I mean, Aristotle had justified slavery and things like that, right? So we want to move on and make it neo-Aristotelian, and in the philosophy of science, it's not adopting Aristotle's particular cosmology of the spheres and the heavens and so on, but some basic ideas. But this is a really, really important movement in contemporary philosophy that I think legal philosophy is only just starting to address. And one of all of these things, and I won't spend too much time going through each of these things, but if you think about kind of laws of nature in analytic philosophy, and you're not sort of steeped in the literature, you'll probably think, okay, that means there are some set laws. Those laws are what they are, wherever they come from, whether they're a matter of brute force or they're just an accident of evolution or they have a divine source, whatever they are, there's these natural laws and they govern things. And the reductive theory of mind that I mentioned before kind of buys into this. Oh, these laws, they govern the chemicals in our brains. We think that we're acting intentionally in a certain way. That's just a phantasm, a deception based on evolutionary sociobiology. And in fact, the only thing that's really operating are these laws. And the overall kind of focus of neo-Aristotelian philosophy of science is you're conceiving of laws all wrong. Effectively, what laws are really powers or capacities of things to do certain things. And this really helps avoid that kind of reductionism. It observes that there are things that exist and they have certain powers and capacities, so there are different layers how we might view reality, but we can't just slice off and say, oh, the most fundamental layer is the law. It's a more holistic kind of thing. All right, so I'll kind of map this back onto my little graph, and I would suggest that arete, so that's a virtue ethics. Arete is, excellence in virtue ethics. It's essentialist and teleological. It can't do away with and shouldn't do away with looking at essences, asking the question, what is a human? What is a person? And it's teleological and has a goal. So as applied to artificial rights and AI systems, whether weak or strong AI, I would suggest these are a couple of the main questions we ask. Does locating a right promote virtues that support human flourishing? And maybe further, in some contexts, does the AI system possess a nature, an identifiable nature that can be cultivated towards some concept of excellence, which would support the idea of a right? So I'm going to map this onto a few things as I kind of move toward the end of my comments. A lot of the existing literature on artificial rights and rights in AI systems that is arguing in favor of according some kind of right to an AI system is making analogies to corporate law. The European Court of Human Rights has recognized that there are human rights in corporations. The US Supreme Court has recognized that there are free speech rights in corporations at Citizen United, and some sort of free exercise of religion rights in corporations, or at least in the owners of the corporations. And of course, the law has long, Western law, Anglo-American law, and the civil tradition has long recognized that corporations are some kind of species of legal persons. So the argument goes, it's not that big of a step to say that an AI system is like a corporation and is some kind of entity that the law may sort of artificially recognize as having some kind of rights. So I think that's an interesting idea, and few problems. These kinds of rights, and I really think it's interesting that a lot of the literature so far in the legal scholarship seems to be about First Amendment rights for artificial agents, and drawing these analogies to corporations. But I think some of us, I would suggest that this has caused a lot of problems in American jurisprudence and policy, at least. I mean, Citizens United, in my view, allows too much influence by corporations over elections. Hobby Lobby, I'm not sure how that case filters out. So there are unintended consequences. Further, the idea of corporate rights is embedded in the existence of the corporation, which is embedded in theories of the firm. Why do we have corporations at all? And there are a bunch of different ways to think about theories of the firm, but all of those, the Coasian idea of a web of contracts, a management or behavior idea where, it's the way you incentivize people. They all see the corporation as centers of human activity. No theory of the firm imagines a corporation existing apart from human agency. And so I would suggest the analogy to corporation law really only makes sense to the extent we're viewing the AI system as something that may benefit humans. And so that's where I tie, it's a little hard to see in my slide, the thing there, but that's where I tie this one. It's interesting. We're still gonna ask questions about human flourishing. Oops, I left my marks on the screen here. Let me just see if I can erase them. Okay, so as we apply it to IP law, most of the discussions about that I've seen about giving IP rights to AI is based on the incentive rationale for AI, which certainly is built into, I would agree, the IP clause in the Constitution and so on. But I would argue, and I've argued elsewhere, that really that kind of utilitarian calculus is pretty much impossible to establish empirically. It's a back of the envelope kind of intuition, but it can even be challenged empirically in a lot of areas. And there are other approaches to IPRs, which I've written about as well. So there are ideas of human development, ideas of human flourishing with IPRs. And all of those, and some of those even recognize that IPRs limit human access to technology and culture or appropriate human culture and may actually harm human flourishing. So we have to raise the kinds of questions, Brian's raising in his idea of responsible AI development, fairness, transparency, accountability. And again, I think these are all questions about human flourishing. And then First Amendment law. Let me try to go to my thing and erase them again. So existing theories of the First Amendment tend to focus on consequential and deontological rules, which makes sense because those are dominant traditions in Anglo-American law. A virtue perspective, I would suggest, would really look at dignity and the ability of speech and good speech to cultivate virtue. And I think there's actually, I haven't teased it out, I'm not aware of others who've teased it out, but there would be a bit of a tension between a virtue jurisprudence and a modern liberal notion of freedom of speech, because the modern liberal notion says let all speech go and the marketplace of ideas wins, where a virtue perspective might say, actually, there's some speech, there's fake news and memes and other things like that maybe it's good to filter out. They're not helping the community. I don't know how to answer that question. So weak AI is basically a tool in terms of speech. It facilitates or not human speech. And again, I think that relates to human flourishing. Here's a place where, if we are talking about strong AI that could possibly have its own free speech rights, we really have to get into this next box of questions. Does that system really have some kind of nature that we can actually identify? I don't think we can avoid asking that question. Is it a nature that in some way can be cultivated and that therefore both merits and society would want to give its own free speech rights to? I don't have an answer to that question either, but I think that's the kind of question that we have to ask. So I think I'm right up on the end of my time, and I'll put Aristotle and my AI thing up there and turn my screen share off.
Perfect timing, Dr. Opderbeck. Thank you so much. I don't know if anybody heard my alarm go off literally as you finished talking. So what I think we'll do, fascinating, is again, I will watch for blue hands while asking the first question. I want to spend a few minutes on questions for Dr. Opderbeck in particular, and Opderbeck, sorry, and then open the floor for questions to both panelists who remain with us, and certainly give Professor Choi a chance to respond to the question that he was asked before he lost his connection. So that's a lot to accomplish. accomplish in the next, 23 minutes, but I think we can do it. And so I will start with a question, David, to you, and that is a question that's really born out of ignorance, because this is not my particular area, this concept, the philosophy, jurisprudence, et cetera. But I'm curious, you raised a lot of First Amendment parallels. And one of the things that we talk about in my Con Law 2 class a lot is, who gets to decide, right? Who gets to decide what's obscene? Who gets to decide all of these different lines that we try to draw? And one of the students in my group last night raised the issue of bias and how, development of AI can increase bias. And I'm curious to know, you made a lot of references, and again, this is me not knowing the literature, but I'm hoping you can enlighten us, because I'm sure I'm not the only one. You made a lot of references to human flourishing and human values, and it strikes me that we may have some conflicts there. So who gets to decide which are the human values that we're trying to further in this entire enterprise?
Yeah, wonderful question, thanks. And this is one of the places where the development of virtue jurisprudence in general, has work to do in relation to the ancient tradition of virtue ethics, because the ancient tradition is the free man gets to decide, and man meaning literally the free gendered man, right? So women didn't have the same rights, slaves didn't have rights. All of those, obviously, from our contemporary moral perspective, are, whichever of these views you take, we're likely to say, and I certainly would say, is not acceptable. I think my initial thinking along that lines for virtue is because virtue jurisprudence, virtue ethics and jurisprudence are more communitarian, the focus is actually on the establishment of the community. And I'm actually going to then kind of refer to something like Hart's idea of procedural morality in the law. So I am gonna say I do think law and morality are connected. I reject that modern idea that that Holmesian idea that they're not. But I think Hart's notion that what it really inheres in is in the structures that we establish. The ways, so those are structures which allow the community to have that discussion about disagreement and provide the space for the community to decide together what is the virtuous path or the right way to do it. And those are, of course, constitutional structures and the rule of law and the different bodies of legislative bodies and elected bodies and even courts in which we can hash those things out. So for me personally, and I can't speak for this whole developing field in which I'm just beginning to write, right? For me personally, it would be about focusing on strengthening those institutions which allow in the political realm, the community to have those conversations.
Thank you. I have a follow-up to that, actually, and it gets into this. It's not even a substantive question, but I'd like to hear your thoughts on it, David, and then I would be interested in your thoughts too, Brian, as we start to open this up to a more general Q&A. But in all of this, one of the things that I've been thinking all morning is, how we get around this problem of silos that we have. David has raised so many questions that aren't in the core legal literature to deal with, right? And Brian has described so many questions that are technological in nature, and someone may have one background but not another. And as we're, as all of you have emphasized, to some degree, the importance of getting this right, because what is done can't be undone. And so I feel, and perhaps you can say that's false, a sense of urgency to sort of get whatever regulatory structure is appropriate decided and in place. And as we're sort of kind of rushing to beat the technological evolution, like, how do we avoid the pitfall of the people in the different silos and the different disciplines not talking to each other? Because we as academics in particular are famous for that. And so how do we ensure that a regulatory structure that evolves takes into account all of these different disciplines?
So we completely restructure the American university and educational system. Although we can't, that's a nice goal, right? So let's be a little more realistic. I completely agree with the sentiment of that comment. One positive thing I think you see, I mentioned in the privacy space, privacy by design. So what you're starting to see, because of the regulatory emphasis on privacy, is when the product is being designed, and there's software products are being designed, you have a cross-disciplinary team involved at the ground in the design, and that includes people from legal, and it might include someone who has some background in the ethics of it all. And I think part of what Brian's talking, and I'll let Brian speak to it, but is also doing this similar thing with the design of AI. And I actually think you see like Microsoft and other companies starting to do things like that.
Yeah, can I jump in? So I have some reactions to your question, which I thought was also terrific. So two reactions. One is, as for engineer, I think law is going to be the place, probably, this is my intuition, where this conversation happens. And so maybe that's my own bias, and I'm speaking to a legal audience, so maybe you're a sympathetic audience. But Jerry Mashah has like a very excellent book about NHTSA and the battle between lawyers and engineers in terms of safety regulation for automobiles. And what he said there was, the engineers had this vision about how they were going to engineer safe cars, and the lawyers won, right? The lawyers just knew how to work the system better, especially in DC. And so, to the extent that we want to bring in these other silos, they have to talk to the lawyers in a way. That's at least the takeaway that I take from that book, which and legal education has gone that route, right? We've gone into a more of a interdisciplinary, multidisciplinary law and kind of approach. So I think there's some promise there. The other reaction I had was there's this ongoing tension or battle going on that I see that's going on between law and ethics. So, and ethics, I think, doesn't mean what I think David Opderbeck means, in the sort of the academic sense. I think in the business community, they're talking about risk management. At least that's, so my colleague Dennis Hirsch here has been talking to the business folks. And what they mean by ethics is they're going beyond legal compliance, but it's because they're trying to manage business risk. The AI community is about AI ethics. The computer science community is trying to teach CS ethics. And the criticism on that is that it doesn't have any hard enforcement, right? So Ryan Kalo has written some about this. I know Rebecca McKinnon has also written some. Plenty of other people have written about how ethics is not actually, it doesn't have any sort of hard stick behind it. So one of the interesting questions will be, is that kind of self-regulation ethics, code, is that going to have some real teeth behind it? And it's going to be better than what law can offer? Or is law going to come in and really figure this out? And is that going to be a more effective regulatory mechanism? I think that's going to be an interesting thing to watch going forward.
Certainly. I think at this point, perhaps we allow Brian to respond to David Rubenstein's question that he wasn't able to respond to before, and then we'll open the floor for the queue for questions for both of our panelists, all of whom have given fantastic presentations today. So Brian, do you want to take it away in response to David Rubenstein?
Yeah, and I was just, yeah, sure. So I was just telling David that I wanted to take a look at his forthcoming piece on ethical AI. So maybe I'll have more reactions after seeing that. The two questions that I sort of wasn't able to get to earlier, the target variables, like how do you pick target variables? I think that's sort of baked into the labeling. So as you're labeling the data, that informs or is informed by the type of target that you're trying to achieve, right? What you're trying to learn or trying to predict. So I agree, that's a really hard question. And maybe to the extent that we think that AI developers, that we should defer to them, that this job is really hard, that there isn't kind of an exact science to it, I think that it would be the place where we would be looking. As for the other question about how do you, I said testing as to accuracy and performance metrics, and you raise the question, well, what about fairness? What about these other values? And I think actually that's, and said, there's like 20 different ways to define fairness or unfairness, and that's certainly where the literature has been dwelling. And I'm not sure that that's the right way to frame the question. Maybe this is, again, my legal bias. There might be certain ways that we care about fairness, but it can't be that we care about fairness in the abstract, right? So we care about fairness or discrimination in employment context. We care about protected classes. We care about in other kinds of areas. But if a business wants to advertise to certain people and not to other people, we're not going to call that an unfair or illegal practice. So is it that every AI algorithm has to be tested by the same fairness metric? I'm not sure that that's the right way to think about it. Instead, it might be that we decide that there are certain contexts where we're particularly concerned. Criminal justice might be one of them. Hiring and employment might be another one. Medical care could be another one. There might be a set of things where we say, you know what, if AI developers can't figure this out, we're not going to allow it to happen. But in other areas such as commercial or postal delivery, fighting wildfires, certain other areas, maybe we're saying, that's not the right thing that we care about. Or if it is, someone should define it. So I do think that's a difficult question, but at least that's my first cut at it. And it's a conversation, I think.
Professor Rubenstein, do you want to respond at all?
Of course I want to, but I think that Brian and I have going to have a nice long chat anyway, because I would love to hear more about his work, and so we could take it offline. Yeah.
Okay. While I am looking for blue hands, I will just pose sort of an open-ended question to our two panelists, and that is sort of looking ahead to the rest of the day. We're talking about machine rights and how we define those and such, but what should we be worried about? One of the things that has struck me in our conversations is just the fragmented nature of our approach to this, and so I'm concerned about that, and you guys can disabuse that concern if you'd like, but more broadly, what should we be worried about as we put this structure together?
Well, so we've got an antitrust case pending against Google right now, right? I'm not sure how I feel about the case, given the antitrust law specifics. But the concern for me is certainly that there's a concentration of a lot of capability and power over these technologies in relatively smaller number of entities that are not democratically overseen. So that, and for me, this is actually a broader concern relating to technology and even internet law as well, is sort of the lack of democratic accountability. And that relates to my concern about legal structure. I don't have an answer for that either, but to me, that is one of the big concerns.
There's so many answers. It's hard to know where to start. I think one concern is what happens to all the data. This is sort of the IP/privacy. I think a lot of companies are worried about. They don't want to release or give access to the data because they're not sure they can protect it. So that gets to some of the democratic transparency questions. But on the flip side, if you do allow companies to protect all that data, is that necessarily a better outcome? I'm not sure how to resolve that. And then there's the international angle. We're not the only country doing this. So, the US, so the White House released this report saying that they're worried about China, for instance. And, is that something, what's that international dimension? I don't know, there's just so much to worry about. I think it's going to be a fruitful area for years to come.
Yeah, if I can jump on what Brian said about the international dimension, I mean, those Asilomar principles I mentioned and others talking about these ethics spent a lot of time thinking about weaponized AI. And that's an enormous issue and a very frightening thing. And what international norm, we have international norms about inspecting nuclear capabilities, which sort of work, sort of don't work. What norms can we have with weaponizing AI? That's a big issue.
Go ahead, Brian, did you want to respond?
I was gonna ask a cross-panel question. I mean, so David, I was watching your panel or your talk, and you said weak AI, strong AI, and you classified deep neural nets as weak AI. Right? I mean, I agree with that. I guess if I'm maybe I'm too focused on the technology. I don't see strong AI of the kind coming soon. Or is that something that we should be worried about in your view in the near-term future? You know, sort of building on Patricia's question.
So we had an AI in law conference a few years ago at Seton Hall, and I remember Ed Felton saying, you know, that's not something to worry about, right? It's not even on the horizon. So maybe he's right. I mean, I'd have to leave that to the technologists. But everything I have read and seen suggests that even for those people who think it's possible, it's at least decades, if not more than decades away. But I do agree, you know, with the sense of the Asilomar principles that even if it's decades or 100 years away, if it's going to happen, when it happens, it's done. You can't get it back. So thinking about it is really useful. I tend to think, just because of my own sort of philosophical views, that it's simply not possible. But I could be wrong, and I'd rather use the precautionary principle and plan for it in the event that I am. For my kids' sake, I guess.
Well, perhaps on that slight bit of uptick after a terrifying last couple of minutes, after a terrifically positive and amazing panel, I think we'll wrap and let everybody get a bite to eat before the keynote speech. But I hope that you all will join me in whatever way we can do in thanking our panelists, who and especially these two who have done yeoman's work with a lot of time and have given us a lot of wonderful insights along the way. So thank you both, and we hope that you'll be able to join us for the rest of the day as well.
Thank you. Thanks, Brian.
Thank you so much.